argue these issues with the court. I just returned to the courthouse. I've been gone all afternoon, but the letters that the court just indicated are most recent additions. I'll attempt to assist the court and Mr. Douglas the best I can.
All right, are Ms. Clark and Mr. Hodgman en route?
I'm trying to reach them, Your Honor.
You should find them.
All right, well, I mean, we've got, okay, well, you've got the list of potential witnesses. Mr. Darden, do you have any information as to, my understanding is you're going to start with certain photographers who've allegedly taken photographs of Mr. Simpson in the wintertime wearing gloves?
That is a probability.
Your Honor, if, I think, like your court said, I know Ms. Clark anticipates arguing the rebuttal of the glove evidence that we just said.
So I'm just trying to figure out who the next several witnesses are going to be. But how about if you get them down here?
I'm trying, Your Honor.
All right.
Perhaps Mr. Darden can talk about the 59 names since he signed that letter.
Well, I assume that since they've told both myself and the jury that they have approximately 5 days worth of presentations, that this is a list of potential witnesses given how things go. For example, Bruce Weir.
Well, of course, we may need him for additional numbers, so that's
Your Honor,
why he's on the list.
as you know, there's a serious issue with respect to the
Scientific
RFLP results from the Bronco, whether that comes in on the rebuttal case that we have to address today. And I submit to you that Dr. Weir absolutely would be necessary if they're going to be allowed to put that in. And then Dr. Shields is going to be a witness in rebuttal, and Mr. Sims is necessary for it. And I think that there's a serious issue there as to whether or not they can present that at all.
All right.
That we have to address.
All right. Record should reflect that we've now been rejoined by Ms. Clark and Mr. Hodgman and Mr. Yokelson.
If the court pleases, Your Honor, can I deal with the lay witness issue and then leave to Mr. Scheck the scientific witness issue?
Sure.
Or Mr. Neufeld?
Sure. Certainly.
My colleagues are prepared to answer the court's questions, Your Honor.
All right. Counsel, we anticipate beginning the prosecution rebuttal case Monday morning promptly, I hope. Who do you anticipate now that you've had some time to contemplate these matters and the other issues have been resolved by the Court of Appeal?
We need to, I believe that the court wanted to take a waiver from the defendant.
That'll
Correct?
take all of 30 seconds.
Okay. Are we going to do that today, or?
I would assume shortly before, out of the presence of the jury, but before we resume on Monday.
Okay. And then we intend, as I indicated to the court, to begin with the glove photos.
All right. Who are your glove photo witnesses?
And Mr. Hodgman has the list on for that. Bella,
I'm sorry, could you just speak a little?
Gordon Bella, Karen Brown, James Chegia,
How do you spell that?
Chegia. Correct. Deborah Guidera, Mark Kruger,
Sorry, could you please spell those names?
Give Reuben.
Kruger is on the 27 on the witness list.
and Richard Rubin,
All right, the
William
first...
Rankin.
Rankin?
Yes, Your Honor.
What is this person's role?
William Rankin is another person with the glove photographs
Do you intend on calling all of these photographers?
to lay the foundation. It's about 1 minute of questioning. Did you take this picture? Yes. When? That's it.
Where?
Where? And where? I mean, the total sum of all the photographers, the number of them is about 10. Their questioning will take about 5 minutes each, if that. And that's it. It's just a foundation for the picture.
All right.
Richard Romano. Richard Roman. Michael Romano. And I said Richard Rubin. Kevin Schott. Rob Seib, S-E-I-B. That's it. And an NBC representative.
All right, after you conclude with the glove photo witnesses, who do you anticipate using after that?
After that, we intend to call Gary Sims.
As to what issue?
That's the blood in the Bronco, the RFLP result on the console.
All right, and are you going to need to recall Dr. Weir?
We need to address the court on that matter.
And what is the status of the DOJ RFLP?
4 probes. There was a 4-probe match to Ron Goldman and the defendant.
As to each?
It's a mixture. I think it's as to each. I'm not prepared to address that, Your Honor. That's going to be addressed to the court by Brian Kelberg. I
All
assumed
right.
it would be Monday.
I would suggest then that we set for a hearing Monday, probably at 5, because we have that issue of the timeliness of performing the RFLP. That's been raised.
Okay.
All right.
We received another order ad this afternoon, and the problem I have is that anticipating that we were promised a report from Mr. Bodziak, we haven't gotten it. I got a report yesterday from Mr. Popovich. Glove photographs were supposed to be turned over, haven't been turned over.
Counsel, let's take this up one item
All
at
I'm
a time.
saying is that I would prefer, and I don't see any reason why it shouldn't be done, that we address this now. I'm prepared to argue it. It was scheduled to be argued. It's not fair to dump all this discovery at the last minute on us. We're going to ask for adjournments. I'm telling you right now, we're going to ask for adjournments because they've been playing with it. They had this stuff.
All right,
They haven't been
counsel.
turning it over. If we can eliminate this
I've
and
heard
resolve
enough.
this issue.
I've heard enough.
Okay.
Thank you. All right, Sims, then probably who? Weir?
Well, depending on the court's ruling, that's what we're going to need to address with the court, as to whether Mr. Sims can be allowed to do the numbers. And then Brad Popovich. Now,
Popovich was who? Refresh my recollection.
Brad Popovich is
Oh, this is DNA, PCR lab stuff.
correct. Response to Gertie's.
All right, and then what topic are you going to move to after that?
Then we'll be seeking to admit the Thanoparatus video under 1202 of the Evidence Code.
The Paratus, okay. That should take all of about 5 minutes.
The Paratus video? Correct.
Yep.
Yeah, that's very brief.
Okay,
Right.
correct. But if you recollect, we had a long discussion about this.
Right, right. The Ackards, I think it'll be Lawrence Ackard and his wife.
As to what issue?
That goes to Robert Heidstra.
What's the wife's name?
Pardon?
What's the wife's name?
Heidstra.
It's the wife's name. She's
I'll
not
get
on
the
the
wife's name and Mrs. Acker.
Right. Patricia Beret also goes to Robert Heidstra.
Is this the person in the pet shop?
I'm sorry, and Christian Anderson. I'm sorry.
Was this the person in the pet shop? Or the
Yes, Your
pet
Honor.
hospital?
Yes, Your Honor.
Yeah.
All right, and who was the other person? After Beret?
Christian Anderson.
Anders.
Right, and that's another witness who received a prior inconsistent statement from Robert Heidstra. Yeah, George Field, number 20, another Heidstra witness.
All right, where do we go after that?
After that, Dr. Don Dutton.
Dr. Don Dutton? As to what issue?
As to pre- and post-homicidal conduct of murdering spouses.
I sense a 402 hearing.
Yes, that may be so. He will be addressing the demeanor witnesses called by the defense, if the court recalls.
All right, if you would, put together your Ps and As on that,
On
both
Dutton?
sides. On Dutton.
Can I get an offer? Will testify so I'll know how to address it, Your Honor?
Do you have a report from Mr. Dutton, or any works or a CV from Dr. Dutton?
I have the CV, but any notes or anything?
The defense has his CV. With respect to his proposed testimony, we will be meeting with him tomorrow, and I will put together an outline of what he proposes to testify to.
Okay, off the top of your head, though, I mean, I'm sure you've had preliminary discussions where you've decided you may call him. Can you just give me a heads up as to where we're going with that?
Yes, what he has done, Your Honor, is he himself has done a study interviewing men who have murdered their wives and reviewed their cases to determine what their pre-offense behavior was, their demeanor, and their post-offense behavior was. And it goes to the issue of what one would expect to see in their demeanor.
Has Dr. Dutton been allowed to testify in any other courts with regards to this?
I don't know.
With regard to this?
You know, I hate to make a representation to the court. My sense of it is that he had. He's certainly very well versed in the area as to what kind of behavior is to be expected, given his studies and his involvement in the field. But I need to get with Dr. Dutton tomorrow to make sure of that.
All right, I'll need to see P's and A's on this. Okay, what do we anticipate going after that?
You appreciate the difficulty in our ability to respond yet until we have a chance to understand more.
But I think the issue is pretty clear.
An additional area of inquiry of Dr. Dutton would be a victim's profile to debunk the myths.
And what's that rebutting, Your Honor?
And that goes to the testimony elicited by the defense from Arnell Simpson, Christian Reichardt. Who else? At least those two witnesses, though, concerning the behavior of Nicole Brown in the time before her murder, her conduct with the defendant. What the defense is going to argue, based on their testimony, Your Honor, is that there were no problems between them because, after all, she was still friendly with him, she was at the house with him, and she had nothing to fear from him. That is a myth that can be uniquely addressed by someone involved and an expert who is an expert in the field of domestic violence, as Dr. Dutton is, he will be able to discuss the fact that the typical battered spouse syndrome, or the battered spouse, doesn't necessarily run away and stay away from the spouse who is doing injury to her, of whom she is afraid. And that would go to address the issue specifically raised with Arnell Simpson's testimony that she saw Nicole sitting on his lap just weeks before the murder, and Christian Reichardt's testimony concerning the nature of their relationship on and off again, coming back to each other, leaving each other.
All right. Where do we go after Dr. Dutton?
And with respect to where we go with that after Dr. Dutton, Your Honor, we will be filing a brief with the court, and we are going to ask the court for the ability to bring in the evidence in the study prepared by Doug Diedrich concerning the rarity of the bronchofibers. We believe that the defense has opened the door to this in two ways. Number one, that in his questioning of Kathleen Bell, Mr. Bailey brought up elicited from her a description of the vehicle driven by Mark Furman, which was a pea green and white utility vehicle. There was no effort made by Mr. Bailey at any time to verify that that was indeed the vehicle Mark Furman drove at that time. I'm sure the proffer would be from him that he attempted to elicit that to show that she could identify Mark Furman, that she did know him, in order to impeach the testimony he gave that he did not remember her. However, without an effort made by the defense to tie that vehicle into Mark Furman, what the purpose of that was, and I bet the argument will be forthcoming, that he had a predilection for that kind of sports utility vehicle, similar to a Bronco. So that's one area in which I think. The other one is the general attack upon the credibility of Mark Furman. In that regard, it was the Bronco fiber that was found on the Rockingham glove. That goes to impeach, what that does go to reinforce the fact that it was not planted, that it was indeed tied to the defendant through the fiber from his car.
Okay, well, put your P's and A's together and but I'd like you to also include in your P's and A's cites to where it is in the transcript so I can
Yes,
find
we
it.
will.
Okay. All right, and then where do we go after Mr. Diedrich?
And Your Honor, this is all within 5 days?
Well, the photographers are going to go, I assume, very quickly.
Mr. Diedrich will address the fabric impression on the envelope to which Dr. Lee testified.
I'm sorry, is that Diedrich or Blasier?
Diedrich,
Fabric impression, that's on the, I'm sorry, on the...
I think it's on the envelope. My memory serves me it was on the envelope.
Okay.
Parallel lines that Dr. Lee testified to,
Okay.
which he thought might be consistent with a shoe print, but which we have determined, I think we have determined, we haven't gotten the report yet, to be consistent with, I believe, the genes of Ron Goldman. And Bill Bodziak to address the shoe prints testified to by Dr. Lee.
Okay. All right, well, that ought to take a couple of days. All right. Mr. Scheck and Mr. Douglas have raised certain discovery issues regarding these matters, and the most difficult, of course, being the scientific witness matters.
All right, may I make just one small suggestion first?
Certainly.
Which is that on this list of 60 witnesses, there are, since there's no indication whether someone is a PhD or an MD or an expert in any field, what we need to know for obvious reasons right now is who on this list of 60 people are intended to be experts. You've, of course, elicited from them several, but there may be many others. One person I see on the list, for instance, is a psychiatrist.
Saul Fairstein?
Yes. although it's not indicated here. What I would ask is, especially if it's the people's position that they intend to complete their rebuttal case in 5 days, given a list of 60 witnesses, and given the obvious limitations that we have in being able to prepare cross-examination of these 60 witnesses, and the special problems that arise when you're dealing with experts, notes, reports, 402 hearings, FRI hearings, and the like, at a minimum, Your Honor, today, so we don't waste a moment over the weekend, we would ask the court to find out from the people, of the list of 60, who do they intend to elicit expert testimony from, and then as to those people, at least, a proffer. So, because we, as Mr. Scheck was pointing out earlier, we need to know what's realistic so we don't go off on wild goose chases in the very short amount of period that we have to get ready for these witnesses.
And as to lay witnesses, Your Honor, we'd like names and addresses because some of these names are new to me.
What concerns, we're just really concerned with the suggestion that this is all going to happen within 5 days. And this list is inconsistent, frankly, with that representation. So at a minimum, Your Honor, right now we need that. We need to know who the experts are, and a very brief proffer, not an unextensive one, but just a kind of thumbnail sketch that you asked for so we can know where we stand.
All right.
I would just remind the court that this comes from the team that repeatedly gave us people on the short list who were never called, people that I have prepared for extensively who were never called, and I didn't find out that they were not going to be called until yesterday. So I just want the court to get a sense.
I have my own list of witnesses that we haven't seen, so
Right, okay.
I understand that. But
in order to...
as you know from our conversation yesterday, Ms. Clark, my biggest concern is finishing this case with an intact jury. And delay is something that will be anathema next week.
I agree with you. I think all of us share that concern, Your Honor. There's no question about it. In order to avoid being precluded by failing to give notice, however, we felt it very important to be as inclusive as possible. We don't want to be caught short that way. With respect to who are the experts,
All right, why don't we go down the list and let's identify who the experts are.
Michael Bodden.
All right.
Now, Michael Bodden would not be called for expert testimony. I think I should indicate that to the court. Michael Bodden, Saul Fierstein are obviously experts. They would be called for the events of June 17th.
What's the profit for that, if I may ask the court, Your Honor?
We're talking about the chase.
Recall there being any defense case witnesses that would have raised that issue so as to make this a proper...
Well, that's a scope issue. What we're going to do is identify experts.
Very well, Your Honor.
All right, we're not at the scope issue yet.
Yes.
Okay. Bodden and Fierstein, you were only offering for their non-expert observations of the events of June 17th.
That's right, Your Honor.
Okay. Bodziak is an expert.
Except, let me make one proviso on that. With respect to Dr. Fierstein, he will be able to tell us the effects of Xanax, which were found in the defendant's possession on June 17th.
All right. Doug, let's see, I have Mr. Bodziak as an expert.
Right. And I've already informed the court what that's about.
Right. Douglas Diedrich,
And the court knows what that's about.
Peter DeForest.
And that's that goes to the SOX.
Yes.
The court's aware of it.
I know who.
Well,
Mr.
Just to remind you, Your Honor, there's two issues on DeForest. One is that you're reviewing other material to see if it's radio or exculpatory material. And two, although the people have made one representation that his testimony would be about SOX, I just would like a thumbnail sketch proffer. What other topics is he going to be addressing? Not in detail, but what other topics so we can look into
Well,
it.
let's go through here first and see if who the experts are,
Then go back.
and then we'll go back and see if there's anybody who's a mystery to you. All right, let's start at 20. George Field.
Okay. None of those are experts until we get down to Roger Leach.
All right, and who is Roger Leach?
And Roger Leach is an expert pertaining to the rarity of the Rockne virus.
Okay.
And let me indicate something to the court with that, in that regard, if I may. Roger Leach, and skipping over to the next page. I don't know if they're on yet. Norm Anderson, and David Boyd. Okay, those three would all be called in expert capacity concerning it's the manufacturer of the fiber. Each one would be giving testimony of about 10 minutes in length, because all they're going to say is, for example, Roger Leach would go to the fact that the dye used for the carpet fiber that was identified by Doug Diedrich was used in this time frame by his company and put in and sold and put into these kind of cars. That's it. And with respect to Norm Anderson, this kind of carpet, this cross-section of carpet fiber was manufactured between these times, and that's it. So we're talking very, very limited testimony from these people.
All right, who else are your experts on your list? Brad Popovich.
Right, Brad Popovich.
How about Stephen Oppler?
Stephen Oppler is a DA investigator. He's just there to authenticate the Paratus video.
All right.
And Rich Rubengalker as an expert who was for examples. Gary Sims is already known. Chris Weir is known.
All right, what is your, I'm concerned about the presence of Leroy Taft.
Again, okay, with respect to, I'm sorry. Leroy Taft and Kathy Randa, I believe, are on the list because we intend to, as part of the events of June the 17th, present the fact that they, within minutes of Mr. Simpson's departure from Mr. Kardashian's house, went to the Union Bank, to his safe deposit box, and recovered large sums of cash in a briefcase. This all goes to part of the chase, which goes to consciousness of guilt. And we would ask leave of the court to file P's and A's on this issue for the admissibility of this testimony if that's in question.
I think it's a scope issue, wouldn't you say?
I understand.
Okay.
That's,
All right.
Your Honor, my understanding is that witness has recanted that version. So I think there's a foundational issue as well.
What?
Should talk to me again.
Okay, we've identified the experts. All right, Mr. Neufeld, and either you or Mr. Scheck, why don't you address your concerns regarding the status of our discovery issues?
Your Honor?
Sorry.
I'm sorry. I'm not the one who's privy to that information, and Harmon is the one who is. Concerning the RFLP results, is that what you're...
No, I just mean all the expert witnesses. I'm just interested in what the status is regarding all of these people and all their reports, et cetera, et cetera. Speak of the devil.
Yeah, there are also discovery issues after the gloves.
Just as a procedural matter, would you prefer to deal with the discovery, or would you prefer...
No, I want to get the discovery issues out of the way first.
Before we deal with the scope of rebuttal?
Yes.
Okay.
Yes. I would rather have you preparing over the weekend. All right. Norm Anderson, number 5. That was as to, Norm Anderson is one of the fiber people, correct?
Right.
Do you have any reports from this person?
All of the information that they would testify to was turned over in the People's Case in Chief when this issue first arose.
All right. Michael Bodden then is not being offered as an expert.
No.
Mr. Bodziak is one of the issues that came up before. You've turned over his notes, correct?
Yes.
Are there any other notes or reports?
Your Honor?
Yes.
May I point out that Mr. Goldberg indicated to me he was unaware of it, but as the court distinctly recalls, Mr. Hodgman and Mr. Yokelson represented to all of us that we were going to get a report from Mr. Blasier. It's insufficient to simply say he's going to testify about shoe prints, because that's what he did on his testimony in the direct case. What is he going to testify to in rebuttal to Dr. Lee in regard to which exhibits, which scientific tests? In addition to that, it appears now from pictures that were given to us yesterday that the genes were, without notice to us, used in a fashion where it appears, Mr. Goldberg informs me, that we have a picture of Ron Raquel doing something or taking an impression of them, which was then sent out to the FBI. We weren't given any I don't know if that could potentially be a destructive test. We weren't given any notice of that.
What kind of test was this?
I don't know. They were manipulating the imprints on the genes in some fashion, whether to take impressions of them or not, to send them to the FBI for purposes of testing. Now, what's quite aggravating is that as we are discussing the scope of all of this and what discovery should come over, and we're trying to find Mr. Goldberg to find out what dates contact sheets were turned over and the rest of it, they're off doing these things without giving any notice of potentially destructive tests, so we could have somebody present to see what they're doing and get some handle on this, and at least request permission to be present when any impressions or testings or comparisons were being conducted by the FBI. They're doing this now. Mr. Goldberg told me yesterday, and he can speak for himself on this point, that these fabric things were being sent to Mr. Diedrich and they were going to find out what the results were. I think he said that this morning. Now I'm finding out something this afternoon. There's nothing here. But I think it's really improper that they didn't give us any notice whatsoever that they were even going about doing this so we could have somebody present to make a record of it, and if it potentially was a destructive test. That's one thing. The second thing is, it's not enough to say that Mr. Bodziak's going to testify about shoe imprints. It's got to be directed towards what, if anything, he's going to say in rebuttal of Dr. Lee on what specific points of evidence, because he testified to the other stuff on the direct case. We've gotten nothing here, and they told us they were going to give us this a week from now. And it seems to me that there's a big double standard. They shouldn't be allowed to take advantage of the fact that we're all sick and tired of how long this is taking, and the jury is sick and tired, and we're all on edge. But the point is, I will not, in behalf of this client, permit this kind of situation where we're going to be ambushed. It will not happen. I will ask for an adjournment and take as long as it is need be to have the appropriate people look at this, and I protest the potential destructive tests on this evidence without notice to the defense.
Mr. Goldberg?
I thought it was the court that decided what was going to be allowed and not allowed, not Mr. Scheck. But maybe I'm mistaken about that. As to the test impressions, Your Honor, first of all, these test impressions are non-destructive. When Dr. Lee testified, I learned for the first time during his testimony that he had concluded that the shirt that was worn by Ronald Goldman, in his opinion, could not have created the impressions on Ronald Goldman's genes. He had previously told me in telephone conversations that we had had prior to his testimony that he believed that the genes did not create the impressions on the evidence envelope or the piece of paper. I assumed, I do not recall asking him, but I assumed, because it is a standard forensic practice, that Dr. Lee took test impressions from Ronald Goldman's genes and from his shirt. I was flabbergasted when I learned that that was not the case, and that he was testifying to an elimination without having made a test impression. When I spoke to Mr. Bodziak about this, he informed me that you have to take a test impression in that situation. I told him that in my opinion, it seemed to me that the genes could not have created the impressions on the envelope and the piece of paper, because I thought that just from my knowledge of lay knowledge of genes, if you press them down on a piece of paper, you'd get a flat impression, that you wouldn't get parallel lines. Well, I was incorrect in that assessment. And we have taken these test impressions, which is a non-destructive technique, in order to send them to the FBI, and did so immediately upon learning of this potential problem with Dr. Lee's testimony. So I don't see any basis for
What is
complaint
the
here.
medium used to take the impressions? I mean, do you press it into wax?
It's something called an identicator.
That's
It's-
helpful.
What? Your Honor, I had never heard of it before, and it's a very nifty little device that we were sent by Mr. Bodziak that allows you to, well, for example, you can put your finger on it or any other object, and then you put your finger on a piece of chemically treated paper, and the print then appears on the chemically treated paper, and there is no noticeable residue left on your finger. So it's a nifty little gadget that...
Sounds like the kind of thing that
yeah.
one does with check
Well,
identifiers. Anyway, Mr. Scheck?
just looking at this picture that they gave us, it appears as though it left an impression on the blue jean. My point is, if he doesn't know whether it's non-destructive or not, whether it's going to change the imprint impressions on the blue jeans or not, it certainly was appropriate to notify the court that is the practice, that is the Griffin problem, that what was going on here. This is
addressing
wrong.
all of Mr. Scheck's issues. No, this is clearly, without any doubt, a non-destructive test. It's not even a test, it's just taking an impression. I mean, we all know what impressions are, and we took impressions, and I think we're entitled to do that without any question. And we wanted to do it as quickly and expeditiously as possible so that I could send these things out immediately. They arrived, I think, a couple of days ago at the FBI, and the analysis is underway. Obviously, we want the opportunity to be able to present this evidence. Now,
Who will be presenting that? Mr. Diedrich?
it's going to be a combination of Mr. Diedrich, probably mostly Mr. Diedrich, and perhaps Mr. Bodziak as well. Mr. Diedrich apparently has expertise in fabric impressions, and Mr. Bodziak has expertise in shoe impressions. So it's sort of a dual testimony that will be presented
So
to
what is
address
this?
this issue.
So, but this testing is still ongoing.
Well, I wouldn't call it testing, it's a comparison.
All right, do you have any results yet?
I don't have any results other than tentative results that have been relayed to me by Mr. Diedrich.
And what are those tentative results? What do they tell us?
That he thinks that, and I hesitate to repeat them because I may be misstating or oversimplifying what he told me, because he has not completed his analysis. And as the court knows, forensic experts usually don't give you much of anything until they're comfortable, they've reached a certain state of comfort with respect to their analysis. But reading in between the lines, my interpretation of what he was saying is that the marks on Ronald Goldman's jeans are consistent, or may turn out to be consistent, with the shirt, and that it does appear that the marks on the eyeglass envelope and the piece of paper are consistent with a Levi's blue jean. But as I said, he hasn't finished his analysis yet.
When do you
And I'd also remind the court that Mr. Lee obviously just testified about a week ago, and we did try to get on this very promptly in terms of taking the impressions and following up on this. And it was in relationship to Mr. Lee's testimony. And I will point out that that was not in any report or notes of Dr. Lee that he had excluded these two items. And the only reason that I knew about the jeans is because he had told me about that orally, and I learned about the shirt on the witness stand. And I didn't know that he didn't take test impressions from that until he testified on the witness stand. Now, as to the issue of reports, Your Honor, I agree with Mr. Scheck that there appears to be a double standard here that's being requested, because they have said over and over and over again that there is no duty to create reports. That is an argument that the court is very familiar with. And they have said that they have not asked their experts not to create reports, but that their experts simply don't create them. In this particular situation, Mr. Diedrich doesn't have a report yet. Mr. Bodziak is going to be testifying in, I believe it's Miami on Monday, and then he has several other commitments, so he hasn't written any additional reports. However, I will say just as a little hint that I don't think we're obligated to give, that if counsel looks very, very carefully at the discovery materials, they will find what obviously Dr. Lee found, because Dr. Lee said that he disagreed with the report of Mr. Bodziak. So this is a subject about which there already is some materials that the defense has and may want to take a look at. Perhaps they should have taken a look at it a little bit earlier. But the point is that in terms of our discovery obligations, we have not told Mr. Bodziak either to create, at least I have not, told him to create or not to create a report. I simply asked him to try to look at some of the materials and photographs we sent, and the same thing is true with Mr. Diedrich, and they will do whatever they normally do. And I do not know how the defense can now argue that we are entitled to create something that does not exist when they have always taken the position that that is not required under 1054.
As to Diedrich and Bodziak, what kind of notes have you produced with regards to this latest testing?
There is no testing.
I mean, as to any of their activities in response to Dr. Lee's testimony, any notes?
No, Your Honor. The items that we sent, I believe, arrived, or Mr. Diedrich opened the box that contains the test impressions on either Wednesday or Thursday. And then there's also some photographs that we sent to Mr. Bodziak, which he looked at and opened the box the first time yesterday. So this is all happening very rapidly, and to my knowledge have not generated any notes other than that which Mr. Bodziak had previously generated prior to his testimony on the witness stand when he reviewed the items, including the jeans and the eyeglass envelope and paper.
All right. Some concerns. First of all, let me mark two pictures. P4.
Well, counsel, we're not going to hold a hearing right now to see whether or not this is a destructive or non-destructive test.
I understand that. I'm just passing up the photographs so the court can look at it to see whether my concern is made up or if it's evidenced by the photographs.
No, counsel, I share your concern about what may or may not be there as a result of having taken impressions from the Levites. The problem is we need the witness here, probably in a 402 hearing outside of the presence of the jury, to tell us what kind of tests these were.
Well, but my initial concern, first of all, and I want to make clear, is that they had no right to do this without notice. And that was wrong.
All right, counsel, we're here to find out
Secondly,
what materials you have.
I have nothing.
All right.
Secondly, it's very well for Mr. Goldberg to say that they're not going to ask him to write reports, but Mr. Hodgman and Mr. Jokelson, while he's off dealing with him, have told us, told you, told me on the record that Mr. Bodziak is going to be asked to fill out a report, and yes, they would get a report from him. So it seems to me that that is improper. It's one thing if it's not their normal practice to write a report. It's quite another thing to come in and tell us that they were going to get a report, and we're going to get it at the beginning of the week, and we get nothing.
And if you recollect, I told you I would be surprised that Mr. Bodziak did not produce a report.
That's right.
Jokelson and Mr. Hodgman have informed me, and I asked them about this previously, that that is not what they stated, and that they stated that if we got a report, they would turn that report over. They did not say that we were going to create a report, or they were going to ask Mr. Bodziak to create a report. And that is the representation that they made to me when I asked them this issue earlier this morning.
All this goes to timing. And it seems to me that we're in no position, given these activities and given these tentative results and given the way they went about doing this without notice, so that we could monitor this. And they have everything we've done. They've had somebody there looking with a video camera, taking pictures. It's very upsetting that we're going to be ready to deal with this at all. I mean, right now, we don't have a date certain where we've seen Note 1, Report 1, Comparison or Examination 1 as to any of this.
All right.
we're putting everyone on notice that we're going to need an adjournment.
Maybe Mr. Scheck can put us on notice as to what statutory provision, case law, or order of this court says that we can't examine the evidence without notice to the defense. I am unaware of that. It's never it's unprecedented
I know you're
in our
unaware.
legal system.
I understand
It has
you're
never
unaware of
happened
that.
here
Wait,
before.
wait.
But we had Griffin
Wait.
rulings in this.
All right. All right, DeForest, you've turned over the, his notes. I'm still going over the notes to see if I find that there's any Brady material in there.
In addition to that, Your Honor, I'd like a proffer at this time as to DeForest. They've already told us they intend to use DeForest
Socks.
on the sock to rebut McDonald and Lee on the third surface from the ankle stain. Are there any other subjects?
Is that it? DeForest, Socks.
May I allow Mr. Hodgman to address the court, Your Honor? Could I be excused, please?
Mr. Hodgman, DeForest, Socks. And let me just add this, counsel, in my review of all of DeForest notes, there are some things that I need to ask the prosecution about with regards to Brady materials. So I'm going to, who is handling DeForest?
In terms of the actual testimony, that hasn't been decided yet, Your Honor. I've been talking with Mr. DeForest over the
okay.
past several weeks.
For the purposes of the 1054.7 hearing and the Brady hearing,
I'm the one.
you're familiar with the materials?
Yes.
All right, then I'm going to direct you to be in my chambers on Monday at 8:30. I have some questions to ask you about some of the notes.
Very well.
Okay.
You know, and, Your Honor, just to advise court and counsel, whether Mr. DeForest testifies at all remains a question. I'll be speaking with him again tomorrow. And I should advise the court as well, with regard to Mr. Bodziak, with regard to Mr. Diedrich, and Mr. DeForest, as far as I've been advised, these individuals have schedules other than just responding to us. And you know, there sometimes are practical problems even making them available to us for moving the case ahead. With regard to Mr. DeForest, I'll be speaking with him tomorrow morning. At this time, I would anticipate his testimony would cover the socks. We've provided all sorts of discovery with regard to that. As to any additional areas, I think it's very questionable at this point in time.
Your Honor, the only concern I have about it being questionable is that we were told about 3 weeks ago that other items of evidence were also forwarded to Peter DeForest in New York, besides the socks. The envelope, for instance, the bindle from item 47. So, again, just to avoid the problem of ambush here or some last-minute change in this, they knew 3 weeks ago when these items were sent to him what his reaction was to these items, and if he was going to be providing expert testimony to refute defense experts. And it's difficult for me to accept that 3 weeks later, when the defense has rested, for all intents and purposes at least, although we haven't done it officially yet, that they don't know yet if he's going to be addressing these other issues for which he received the evidence to examine more than 3 weeks ago.
Well, it seems to me that they've had the opportunity to review his notes, and they've decided so far only to offer him as to the socks. If that changes, then we can take it up. But I'll accept Mr. Hodgman's representation at this time. All right. As to, let's see, Leach was one of the fiber carpet people, correct? Carpet fiber people?
Yes, that's correct, Your Honor. Ms.
All right.
Clark is most conversant with that, but I'll substitute in the place.
All right, but those the representation is that what they would testify to was turned over in the report that was provided during the people's case in chief.
And that's correct.
All right. Brad Popovich.
Notes and report have been turned over.
All right. Richard Rubin, are we going to get another report from Mr. Rubin?
No, the most recent
Or an interview or report?
interviews have been turned over. A taped interview and a report as to notes from a subsequent interview were turned over last week.
All right.
In my understanding, there was one picture that was sent back to him
after that interview took place. I haven't heard anything about that.
And Mr. Blasier, you are correct. If I have just a moment. Your Honor, with regard to that last photo, we don't have a written report. We understand that Mr. Rubin's opinion is that it is, the photo that was last sent was consistent, and we'll identify that for you, Mr. Blasier, in the material that, we have some more discovery material that you had asked us to prepare, and we'll turn that over as soon as we get a break.
We have other concerns about discovery that allows our ability to prepare. I don't know if you want to
Right.
do those now or not.
Well, I mean, as soon as we have a break, I mean, where is the material?
It's right here. Mr. Armstrong has it.
Hand it over to Mr. Blasier.
I've been told the reports aren't here yet. You want to hear about whether we can be ready to do this on Monday? At some point, I need to address the court on that.
I just want to make sure that the reports with regards to these experts have been turned over. I'm just about to get to the end of the list.
Okay, well, I just told her the report's not here. On its way down, yeah.
Well, why don't you take a look at and see what you got? All right, as to Gary Sims, this is the RFLP. Mr. Hodgman, as to Gary Sims, this is as to the Bronco RFLP results.
And I'm not the most conversant in that. If Mr. Harmon may take the lecture.
Yes, we've turned it all over. I'd like to clarify. Mr. Scheck complained at the beginning of one of those diatribes about just getting an autorad, and then he generalized that we're playing games. The reason he just got that one is because the date on it is September 5th. So it's a little bit, that's pretty fast, Your Honor. So I think he needs to be a little clearer and fairer or more objective in his complaints. So everything's been provided, or at least until I hear otherwise, I think everything's been provided.
The point, I would respect, since Mr. Harmon is here, I would respectfully request that before the end of the day that we argue this issue, because given the way this discovery is coming in, there's going to be a lot of work trying to catch up with what they're giving us in dribs and drabs, and if we could clarify this, that would help a lot.
All right.
Well, can I know personal commitments don't matter, but my last plane is at 7:30, so, and this was not on the agenda today, Your Honor. This was not on the agenda until 11:59 and a half when Mr. Neufeld, when everybody was leaving court, asked you if we could kind of talk about some of these things. So that was not on the agenda today.
Scope of rebuttal.
Pardon me. Mr. Sims was here yesterday. I know we've discussed this many times as this trial has progressed. Mr. Sims was here yesterday. If somebody really wants to hear why it took so long, there's only one way, and that's to have Mr. Sims here with all of his timesheets, and he's just not here. So I have no idea what the legal issue is, no matter how many times I hear about the complaints. So I don't think it is appropriate. I know this is something they've known about since July, by the way. So this is not a surprise. The other shoe dropped, then the other shoe dropped, then the other shoe dropped, then the other shoe dropped on September 5th. So this isn't a surprise that 4 shoes have dropped on this set of mixtures. But if they want to have a hearing, we can have a heck of a hearing. It's going to take a while, and I'd like Mr. Sims to fully explain everything, including all the time that Dr. Blake took of his during this. So that's the only problem. I know they really want to do this now, but we can discuss it superficially. But the only real way to get to the bottom of this is to put Mr. Sims up there and let him explain. That's going to take a long time, but
All
That
right,
would
when
be
will
fine.
Mr. Sims be available next
He'll
week?
be here Monday morning. He'll be here Sunday night. We could do it Sunday night if they want to find out about it before Monday morning. We'll be on a 7:30 plane down Sunday night.
If I might, very briefly, I've reviewed the record on this. It was scheduled to be done today, not the day before, as soon as we got an opportunity to take up the scope of rebuttal arguments. And there's no need to call Mr. Sims on anything because the record is very clear. In March, this court granted them permission to combine the samples, 303, 304, 305 from the Bronco. Almost at that point, we began a discussion about the fact that immediate testing would be necessary in order to make sure that this evidence would be available for the end of the prosecution's case, whatever the results. And at that point, I began saying that this would be improper to raise it on the rebuttal case. And I commend the court's attention to the transcript, page 27331. We discovered, and you did take testimony or statements from Mr. Sims on this. He wasn't quite sworn in, but he was sitting in the audience. You indicated that when they were given permission to combine the samples, it was the understanding, and you said at page 27331 of the transcript, it was all our understanding in March, that testing would begin immediately, if not sooner, quote unquote. That's what you said. Then it became apparent that initial quantitations were done, but no RFLP testing had begun on earnest. And then we had a discussion of this matter in May, when it was revealed that they hadn't done anything for a month and a half, except these initial quantitations. And at page 27332 of the transcript, you asked Mr. Sims questions about whether or not, how long it would take to finish the test. This is on May 12th. And he said a month and a half to 2 months. At which point, and I was arguing then that this was improper because they should have started it earlier, because it's something that could have been available for them at the end of the prosecution's case, and it was going to create an unfair situation if they were going to sandbag us with this issue on rebuttal. And the court's statement and resolution of this issue at page 27340 was, well, I don't have to reach this now because, quote, we may have a preclusion by the passage of time. So the court gave a very clear signal to the prosecution that, A, it was expected once the stains were all, the permission was given to destroy all that evidence and combine them, that the testing should commence immediately, if not sooner. B, the record has already been established that they didn't do that for at least a month and a half, if not longer. C, in May, Mr. Sims, in response to the court, indicated that it would take 1.5 to 2 months to do the test, so it still could have been done before the end of the prosecution's case, and it was not. They delayed even further. Now, the point is, if one goes back and looks at the transcript, Mr. Harmon and the prosecution has taken to the position since the beginning of this case that they had a right to do whatever testing they wanted, exactly when they wanted it, that they were under no obligation in terms of reasonable necessity or timeliness to do it in a fashion to get it done when the case started. And we went through that and we litigated that, and the court gave them permission to do that. And he was taking the legal position then, well, we can do it whenever we want to. And the court gave very clear signals at the time that permission was granted for them to combine all these samples, that it should be done, testing should commence on that immediately, if not sooner. Then the court gave a very clear signal that preclusion by time would happen if they didn't get it done by the end of the direct case, because it's something that was available to them. I raised the issue that in terms of the law of rebuttal, that if, I think there's 3 factors here, would it be available to them on their case in chief if they proceeded reasonably and as the court directed it would have been? Would there be prejudice if we were confronted with crucial evidence, a second factor, in an untimely fashion? No question about it. It made it very difficult to form the defense case, not knowing what the results from that would be and how. And then finally, a factor to consider in terms of the law of rebuttal, as indicated in our memorandum, would this unfairly highlight this evidence at the end of the case? Now, I think it's very clear, and I alerted the court and the court alerted the prosecution to exactly what they were doing. This was planned. And so it seems to me that this issue is already framed by the record as it stands. Finally, and this is another factor I think we have to take into consideration from the reports we were just given, is that this is a complicated mixture. Dr. Weir, in a very baleful way in his report, indicates that he has done some analysis here that he gave us, but he hasn't even completed what he considers the best analysis. And I'm sure the court won't forget the analysis and analysis and analysis over days that was being performed by Dr. Weir as he recalculated things while we waited for that to get done. And this RFLP mixture is something that we would definitely have to rebut with Dr. Shields on our case. So it seems to me that that is another factor in terms of the interest of justice considerations and the timing of this trial that should weigh heavily in this decision. But I don't think there's any question that they knew this day would come. And they were given fair warning, and the record is clear and complete on this point. And I would very much like to resolve it because we need to prepare in terms of all the other discovery that they're throwing on us at the last minute. And I can tell you, we don't like the idea of having delays, but we're going to be forced to do it in terms of this imprint evidence, in terms of this glove business, all of it.
Just a couple points. We look forward to Dr. Shields, who calls himself a hemigod, coming in. You recall him in that hearing out of the presence of the jury. So we anxiously await his appearance in this courtroom. I would like the court to remember that every time this has come up, Mr. Scheck has told you that all that evidence was consumed. And each time that he does that, I remind him that was not true then, it is not true now. And if someday I'd like him to be held accountable for continuing to tell you things that simply don't come close to the reality. I have my own notes compiled, a 10-page chronology beginning March 9th through August 3rd that I would like Mr. Sims to recount to you, because once again, it bears no relationship to Mr. Scheck's perception of what really happened through the course of the testing in this case. And for example, the defense knew before we rested what the results of the first probe were. They knew that. So to say that they never knew that and couldn't formulate their defense, they knew what the PCR results showed. So they knew where the other shoe was going and the other shoe was going as long as we could keep testing it. All I've asked you for is an opportunity. I'm not here every day, but nobody has told me that this was scheduled for today except Mr. Scheck, and I'm not aware that it was. Mr. Sims was here yesterday, prepared to testify in the case in rebuttal. So I want an opportunity to convince you that once again, Mr. Scheck has not fully informed the court that contrary to popular belief, there are people who have other things to do in their professional and personal lives. There are deaths in the family, as you recall, a long period of time when Mr. Sims was here in this lovely city, waiting to testify, preparing to testify. So that's all. I want just a fair chance to convince you that there's not any factual merit to what Mr. Scheck has told you, and there's no legal merit to it. I mean, that's one thing we've never come to grips with, that there's no legal merit to it. But I think you can easily resolve this on a factual level, and that's all I want a chance to do, is convince you with Mr. Sims here.
All right. I agree at this point that I need a factual explanation as to what testing was done, what the scheduling was. I am concerned, however, about that 6-week delay between the time that the issue was presented to the court to allow the combination of those samples and before the actual commencement of the testing. I am concerned about that.
Absolutely, and we intend to address that with a day-by-day account.
All right. And he'll be available Monday?
Yes, Your Honor.
All right. Next issue. Sure.
Just for my own scheduling purposes, that's a hearing.
No, he's just,
we're not going to start with him. We're not starting with, I mean, you would have a hearing about whether or not it can happen, and then there'd be another day that he'd come back and testify to it if we lose.
Well, can we leave that open? I mean, if you allow him to testify, he's here. We would hope you would allow him to testify forthwith. That's a
But
discussion.
what I'm contemplating right now, Mr. Harmon, frankly, is, as I indicated to counsel, my concern is, all right, as I've indicated to counsel, my concern is getting this case concluded. So any of these special hearings are going to be days and times that aren't normally scheduled to be with the jury. So my guess is that we'll conduct this hearing Monday at 5 o'clock.
And hopefully if you...
Because I assume that despite the fact that people say these photographers are only going to take 5 minutes apiece, I've never seen a 5-minute witness in this case, so.
Just so the record's clear, Mr. Clark is making Mr. Popovich available to me tomorrow for a conference call. So I'm going to be spending my time with Mr. Popovich. I'm not doing one thing about Mr. Sims until we resolve this issue. And if we do lose it, I'm not ready to cross-examine him right afterwards. I just want to make that clear. Okay.
Is it okay if I don't do anything then either? Or can we both not do anything?
Have a nice day, Mr. Harmon.
Thanks, Judge.
You're welcome. All right, Mr. Blasier, as to glove issues.
After discovery?
Yes.
Last week, I think on Thursday, you ordered that the prosecution provide us with equal quality photographs that they intended to use. And this might help to explain what Mr. Rubin is doing. His testimony is to the effect that he's looked at some pictures, and Mr. Simpson is wearing some gloves at some football games in the winter, and he says, look like Garris isotoner to me. Now, I don't know whether that's the proper subject for expert testimony or not, somebody looking at a picture and saying it looks like something. He's not going to say it's the gloves in evidence. He can't say that. He acknowledges that. We didn't get those pictures. Obviously, for me to show pictures to other people who might know about gloves, I've got to have the same pictures of the same quality, the same size gloves, whatever, so that I can have experts look at them and tell me, what do you think? I also might want to make my own pictures of gloves that we have that look very much like these gloves and do them in the same size, the same resolution, to test Mr. Rubin's ability to recognize different kinds of gloves. I don't know. The point is, I got 17 pictures at 2 o'clock. I've been handed another 27. Very nice pictures. I feel like it's Christmas. They're wonderful pictures. But what am I supposed to do in the 5:30 on Friday afternoon when I'm supposed to cross-examine 10 people on Monday? I've been asking them every day, can you give me an idea which of these pictures you're going to use and who you're going to call? Ask Mr. Yokelson almost every day, and he's very pleasant to me and shrugs his shoulders, says, I don't know, I can't tell you. Ask Mr. Fairclough every day. I don't know, can't tell you. Now I'm told that they have 11 people coming in on Monday, most of whom are from different parts of the country, and I have to assume that they made some decision before 2 o'clock this afternoon to bring people in from all over the country to put on all of these pictures, many of which, by the way, are pictures of Mr. Simpson wearing black gloves and not brown gloves. Nonetheless, I can't be ready to cross-examine 10 people on evidence that I just got this afternoon. This is a weekend. We've been in touch with glove companies. I've got 30 pages of lists of glove manufacturers all over the world, some of which we've already contacted. I've got gloves coming from Italy. This is the weekend. I can't prepare for this on Monday. This is ridiculous. This is not fair. Forget the beyond the scope argument. This is just not fair. And we're not ready to do this on Monday. We'll certainly have objections to cumulative. A lot of the pictures are just duplicative, so we may be able to weed out a lot of these people that way. But I'm not even ready to argue that until Monday. If they want to spend the taxpayers' funds to bring all these people in, we'll argue that Monday. But it's not reasonable to expect that we can be ready on this kind of testimony, getting this stuff now, on Monday.
Mr. Hodgman, when were these photographs available?
Your Honor, most of these photographs were available before today, and we provided the best available copy that we had to the defense before today. I don't have a list before me with all the dates, but as Mr. Blasier well knows, we've been providing for well over a week either laser prints, color laser prints, or the like. As we indicated to the court and counsel, we did not have negatives ourselves. We had to take what was sent to us by various photographers. We had to go back and implore, ask, and otherwise attempt to obtain negatives so that we could comply with what Mr. Blasier asked. That is that they obtain a like quality photograph of something we intended to present. The vast majority of those negatives came in either yesterday, and actually the vast bulk of those came in this morning. We cleared our photo lab and pushed out those photos that Mr. Blasier received today. There was no delay in turnaround. They got them just about as soon as they came out of the developing tank, and we provided better quality material than we had ourselves until yesterday and today. So there was absolutely no delay in getting the negative quality prints to the defense.
I think the court needs to be aware that I've been watching the reports as they've dribbled in this week in terms of where these things came from. And every report that talks about when they got the picture puts the date at before they rested their case. These aren't things that just came in today in terms of them knowing about them. There are several reports that came in this week that don't have dates in them. The date that they received the picture has been conspicuously left out. But the ones where they put the date down, it's all before they rested their case. This is new stuff. We've been asking for this for a long time, and now we get it Friday afternoon, 5:30.
And for well over a week, they've had prints, the same thing that we have had, Your Honor.
All right, do I have a scope problem here if these matters were available to you prior to the resting of your case?
I was just hesitating because we did file a brief in response to the defense objection on the scope argument that I'm prepared to handle. If you want to.
And I'll defer to Ms. Lewis on that if the court wants to argue that now. But as to the scope problem, I'll tell you just as a brief matter of fact, most of the glove material came in after we rested. I think there was 2 different submissions that I can recall, and one of those we're not even seeking to introduce. Be my guess.
I was just handed a brief. Was this just filed?
We filed it early this afternoon,
Okay.
earlier this afternoon.
Well, obviously, I'm not prepared to respond to that, but
All right, Ms. Lewis, does this brief deal specifically with the gloves?
Yes, it
Dates,
does.
times?
In terms of the scope argument, Your Honor, there is case law supporting, it does
No.
not matter.
No. Does your brief specifically address the glove issue? Yes or no?
In a broad sense, yes, it does not detail the dates in which everything was received.
Okay. All right, then I guess we probably ought to take that up first thing Monday morning, scope of the glove presentation. But I'm going to need dates, times, declaration as to when those things were.
Your Honor, please don't get offended before you've read the case law cited in my brief, because it does not matter. The court may agree with people's position that under much of the case law, it's,
Well, since you just filed it, and obviously I've been busy all afternoon,
I can appreciate that.
haven't seen it, haven't read it yet. All right?
the court's aware that we made certain tactical decisions on the defense based on
No,
them
I'm-
not doing this before.
Thoroughly aware of that, counsel. There are several tactical decisions that have been interesting. All right, experts, gloves, what else do we need to resolve now, since we're not resolving much of anything?
What I would suggest, Your Honor, if it's acceptable to the court, is in light of the fact that I think Mr. Blasier already represented that he will not be prepared to go forward on the gloves, even if you ruled that it wasn't beyond the scope of rebuttal on Monday, and we're not prepared to go forward with those experts right away for a variety of reasons which we've already laid out to the court, I would ask that the prosecution be instructed to be ready with those civilian witnesses who we discussed the other day. We got notice of several days in advance, if you recall, the witnesses pertaining to Mr. Heitscher. There was a flight attendant from American Airlines. The only other point I would make about the witnesses pertaining to Mr. Heitscher, even though the civilian witnesses and we would be ready to deal with them, as soon as prosecution starts the rebuttal case. I would point out to the court that Mr. Darden represented that the Heitstra witnesses are not rebutting Heitstra's testimony, but are simply trying to corroborate it. And if that's really what Mr. Darden means when he says that, then clearly that would not be appropriate for rebuttal testimony.
Well, that'll be part of our scope of rebuttal discussion, I suspect.
And I didn't say
Okay.
corroborate. I
What-
said
what I would-
buttress.
What I would also ask, Your Honor, is that the people be instructed to prepare by Monday, because we're going to be dealing with scope of rebuttal, any points and authorities they have on those other issues that you highlighted, where bells went off, I think, like the Dutton issue, that should be filed by Monday morning so we can respond to it in a timely fashion if we're going to finish this rebuttal case in 5 days, that they also have the points and authorities by Monday morning on the Bronco fiber revisit that they're asking the court to do, and they also have the points and authorities by Monday morning on June 17th witnesses, because if we're going to deal with the scope of rebuttal, we need to have those authorities right away on Monday so that can be resolved. And I'm not trying I think it's reasonable, Your Honor, because there's only so many of us, and if there's 59 witnesses, we have to figure out what the heck to do first. And until you somehow circumscribe some of that,
There's only so many of you?
there are.
There's probably 20 of you on each side, and there's only one of me who has to read all this stuff.
I understand that, Your Honor, and that's definitely a disability, but it would certainly make it easier for you to get started on that if they got the points and authorities and those issues in Monday morning, so we could at least know where we're heading.
All right. Well, I'm going to, as I've mentioned to both sides, I don't tell either side how they're going to put their case on, what order they're going to call people, but it would probably be a good idea that you have people available on call in other topics or other areas in case the worst happens. I don't know. I haven't heard the scope argument yet, but you should be prepared to present some meaningful testimony to the jury on Monday.
We will be prepared. I think
Good.
we can accommodate counsel's request with regard to briefs on the fiber.
No, actually, when the court indicated it wanted the record sides and the fiber, we don't have the transcripts yet for the record sides on Kathleen Dell's testimony, for example, with regard to the type of
These are real time.
automobile that Detective Herman drove.
All right, just I'm going to encourage you to be ready and have witnesses on call to go forward with other areas of your case in case we run into problems regarding gloves.
For the record, Your Honor, and I have some notes here, on August the 30th, following our discussion with Mr. Hodgman about who we were going to be hearing from in rebuttal, he said DeForest maybe, he wasn't sure. He said there was some glove evidence depending on an event to occur on August 31st. He named David Atkins, he named Miss Anders, Miss Barrett, Mr. Fields, Mr. Boziak, and Miss DeTeresa. He wasn't sure about DNA, he wasn't sure about EDTA. Those were the only names we were given. Later, Popovich came up until this list we got today. And that just is intended to highlight the exasperation that we feel at this point, given these abundance of names and the order that is now being presented, which we were not otherwise made advised of before today.
This is rebuttal. Mr. Gordon has informed us that he'll have a brief ready on Dr. Dutton first thing Monday morning. As far as the June 17 witnesses are concerned, they would be toward the end of rebuttal if the court were to permit us to put that evidence on. So counsel will have that additional time, and we'll try and get the brief ready on Monday for that as well. And we'll do everything we can to move it along. We'll be ready Monday morning.
All right. Okay. What?
What's okay?
Okay, they said they're gonna file a bunch of briefs on Monday. We'll have our scope hearing first thing Monday morning. I'll do my 1054.7 Brady and Cameron hearing with Mr. Hodgman at 8:30. 9 o'clock we'll have our scope hearing, and hopefully by 10 o'clock we'll be putting something in front of the jury. All right, and at 5 o'clock we'll have our Sims hearing. All right. I'm tired. It's the end of the day.
I just
Yes.
want to remind the court, I don't know if the court's even aware, we got a served with a pitches motion, which I assume the court that it's noticed for Monday or shortening time on that 30 matter, I believe. So,
Have we heard from the city attorney's office regarding the request for an order shortening time?
We had faxed them today, Your Honor, a copy of the motion we told Ms. House yesterday becoming. She asked that the production be delayed. We asked that the hearing itself be at 9, the production of any at noon.
Okay.
In that regard, actually, if Mr. Hodgman could track the cases involving Detective Purdy and Detective Furman, and we could see if we could link those up as being the same incidents, then I think we would be well on our way factually to getting a more coherent handle on where that's all going.
All right.
Your Honor, one final point. I'm reminded that in view of the Court of Appeals ruling today, we are this weekend reevaluating the wisdom of our choosing to rest on Monday and whether it's appropriate to take other appropriate steps.
I can't imagine why they're complaining about discovery and rebuttal then when they, even they themselves say they aren't ready to rest yet, Judge.
It's because we want to end the case.
All right. I have one other matter that does not involve the parties. We had a violation of the court's order this morning regarding still photography in the courtroom, and I've determined to terminate still photography in the courtroom. So I'm taking Ms. Sager. That's why you're here. All right. Then, if it's of no further interest to the real parties in interest, I'll excuse them at this time.
Mr. Saxon is also here.
All right.
If the court would hear argument about the extra energy, have Mr. Saxon address the court before.
Let me allow counsel to clear. I'm sorry? Thank you. I'm glad somebody appreciates that. All right. Thank you, Madam Reporter. Ms. Sager.
Yes, Your Honor. Mr. Saxon is here with me, who is the still photographer who was running the pool this morning. It's my understanding that what has occurred is, again, simply what I think was a misunderstanding of an incident that's occurred before the court some time ago when a still photographer took a picture during a break, which the court has ordered that no pictures be taken except when the court is in session. But during that hearing, there was a discussion of the need to take a test photo on certain occasions to make sure that the still camera was working. And it was the impression that...
Test photo of the seal.
Yes, Your Honor. At that time, the court made the comment when he was explaining that he focused on people because that's what normally is being taken pictures of. The court made the comment, I believe, something to the effect of, well, that's what the seal is for. And the impression given to the still photographer and to the pool, my understanding...
Ms. Sager, let me tell you what causes me great concern and why I'm going to terminate the still photography coverage, is because when this happened, I heard the camera go off myself this morning when I was here at 8:30, and I was here out on the bench clearing items, getting set up, getting my computers running, making my notes, and I hear the camera go off, and I look and I see it directed towards me. and that's a direct violation of my order.
Well, Your Honor, I believe the court has reviewed the footage, the one still camera shot that was taken this morning. It was not a picture of
No, Ms. Sager, I
the
haven't had
court.
time. It would be a tremendous waste of my law clerk's time to send them down the Fox photo to get 1-hour photos. I haven't had the time to do that. I've been busy with other matters.
I appreciate that, Your Honor, and certainly Mr. Saxon or a member of the still photography pool is happy to take that task in hand. The picture, as I understand it, was not of the court. It was simply focusing on the far wall because the position of the still camera, given the screen that is between the camera and the seal, makes it
And
difficult
I
to
just happen to
focus.
be in between those two things. Isn't that unusual?
Well, Your Honor, if a picture was taken of the court, I could understand you being upset. And there was no intention to violate or
No,
flaunt
I'm
the
not
court's
upset
order.
about people taking my picture. I'm upset about the fact that it's a violation of my court order.
The picture, as I understand it, Your Honor, was simply focusing on the wall so that a focused shot could be taken, which can't be done of the seal with the still camera the way it can of the video camera. And so the focus was on the far wall because if you can't get something in focus, you can't tell whether the camera's working or not. And that was what the camera was pointing at, and the camera was moving around the way it does without a picture being taken to make sure that everything's working. Because unlike the video camera, my understanding is the still camera has to be, taken down or broken apart or broken down, whatever the terminology is, every night. And so they have to make sure in the morning that it is working when they put it back together. And that's the reason a test photo is taken. And Mr. Saxon can explain precisely the mechanism involved in having to do that, but it was not an intent to take a picture of anyone in the courtroom, and no picture, as I understand it, of anyone in the courtroom was taken, but simply a focus on the far wall. And to the extent that was in disregard of what the court's intention was when it referred to taking a picture of the seal, then I know Mr. Saxon is deeply apologetic, as are all the members of the pool. But the intent was to try to follow what the court had implied, or at least was understood, the last time this issue came up, which was don't take any pictures of anyone in the courtroom. You're supposed to do your test shot, if you need to, on a stationary object, the seal, which is what the video camera focuses on when the court is not in session, not taking any pictures of anything or anyone going on in the courtroom. And it's my understanding that that's all Mr. Saxon was trying to do. And he is here and is happy to address the court and has written out an explanation that he's happy to have me submit to the court and would ask for the court's leniency and not punishing.
Problem is, we've been through this once before, haven't we?
We have, Your Honor, but as I explained, the
And
upshot of that hearing...
I thought I was crystal clear.
Well, I appreciate that Your Honor may have thought that, and again, we apologize if there was a misunderstanding, but that's all it was. And had a picture been taken of an individual in the courtroom, then that would seem to be more in line with a punishment that would be appropriate to a flaunting of the court's order. But here, what was done was an effort to try to satisfy the court's concerns that no pictures of people be taken when the court was not in session.
Well, all that had to be done is notifying Ms. Hazlett that there's a technical need to do something, and that a regularly scheduled time that a photograph would be taken of some inanimate object in the courtroom. That was not done.
I understand that, Your Honor, and that, as I said, Mr. Saxon and the pool are apologetic for that,
when
but
I'm
thought they
sitting
were
here
trying to...
get prepared for the morning, and I hear the camera going off, and I look and I see it directed in my direction, I'm concerned.
I can appreciate why the court would be concerned, and that's why Mr. Saxon has wanted to offer an explanation of what happened to make it crystal clear to the court that no pictures of Your Honor were taken or of anyone in the courtroom, nor was there ever any intent to do that. And to the extent that there was a misunderstanding about the intent of the court's order when this last arose, that's all it was. They simply thought that the purpose of the discussion last time was to make it clear to focus on the inanimate object and take a picture.
Mr. Saxon, can you see the clock with your camera?
Yes, I can, Your Honor.
Next time, take a picture of the clock.
Yes, sir.
All right? Fine is $250.
Yes, sir.
Thank you, Your Honor.
I apologize, Your Honor.
Accepted.